Good afternoon, and welcome to our webinar entitled Best Practices for Earnings Calls and Investor Updates. Before we begin, we'd like to cover a few housekeeping items. To ask questions, please use the Q&A widget on your screen. We'll try to address questions throughout the webinar. Otherwise, we'll get back to you via email afterwards. For those seeking CLE credit today, please download the affirmation form and the evaluation form found in your resources widget on the screen. We'll announce the CLE code once during the middle of the presentation. Please return both forms for CLE credit. The presentation and supplemental materials are available for download from your resources widget. We'll also distribute these via email after the webinar. The first quarter of 2020 just ended, and public companies will be reporting their results for the quarter shortly, if they haven't already done so, and we'll be holding investor calls to discuss their results and, in some cases, future guidance. These earnings releases and calls are going to be unlike any before because of the impacts of COVID-19 on the quarter just completed and the unknowable, seemingly ever-changing impact on the rest of the year. We have recent statements by the chairman of the SEC and the director of the SEC's Division of Corp Fin urging companies to be more forthcoming about the impact of COVID-19. We also have investors looking for information about the impact of the pandemic and companies' plans on how to deal with the many challenges they face. Against this backdrop, we thought it would be helpful to discuss some of the issues public companies regularly face in connection with earnings releases and investor calls, and to provide some thoughts on how to think about these issues in the current environment. We have a lot to cover this afternoon, so without further ado, let me turn over the webinar to my partner, Anna Pinedo, to start off the discussion. Anna?
Thanks, Eddie. So we thought we would start with some of the fundamental underpinnings, materiality, the duty to disclose, and the timing of disclosures. So all of our thoughts today, all of our commentary, and all of the advice that we give to our issuer clients is always premised on the basis that we've reviewed with them the notion of what's material to the company. And it's often a source of frustration for issuers that we can't provide bright line tests or bright line percentages for items that will or won't be considered material to an investor. And largely, as you see on slide this slide 3, that's because materiality is a mixed determination. So some questions of law, but informed by the specific facts and circumstances. And almost inevitably, materiality is going to be judged in hindsight, and it's going to be a consideration of whether the particular omitted fact would have been viewed as material based on the total mix of information that was available by a reasonable investor. So that leaves a lot open for judgment and requires that a lot of these questions regarding information that is or isn't material be carefully considered. So the other core underpinning to think about is that a company doesn't necessarily have an obligation, an affirmative obligation to disclose all material events in the absence of a specific, for example, 8K triggering event, or a few other factors that we're going to talk about. So in the context of MD&A, for example, companies have to give appropriate consideration to disclosures regarding trends, known trends. So whether there are certain events that are reasonably likely to occur, and the SEC has given guidance over the years in various MD&A related releases, and most recently in the SEC's proposing release relating to changes to MD&A. That's a useful release to be looking at these days regarding the kinds of events that are reasonably likely where disclosure would be required. So disclosure may be required even when the likelihood of the occurrence of a known trend is less than 50-50. Again, you have to focus on what is reasonably likely, and you have to consider the uncertainties that are known to management. During this quarter, as Eddie said, it may be particularly challenging to provide trend disclosure. But as we'll talk about during today's presentation, it's specifically that kind of outlook or trend information, not necessarily earnings guidance, but trends that contextualize the effect of COVID, for example, on a company's results of operations or its future prospects and future quarters that should be considered. So the analysis for trends is different from the typical or traditional materiality analysis. And as we note on this next slide, essentially there's a lower bar in terms of the kinds of information that an issuer would disclose in a trend discussion versus the kind of information that would necessitate or trigger an immediate duty to disclose. So on the next slide, just a perspective again on this duty to disclose. So we've picked a few quotes from cases when a corporation chooses to speak, even if where it lacks a duty to speak, it has to be accurate and complete. So to the extent that a company, for example, chooses to publish an update, an investor relations update or a market update, and it's affirmatively choosing to do that in the absence of a triggering event that would require, for example, an 8K, it has to make sure that the disclosures in that kind of investor update are accurate and complete and don't omit a material fact that should otherwise be disclosed. However, I think it's also important to balance that with the other aspect, a failure to speak. So a failure to speak is not a violation of 10b-5 unless there were an affirmative duty to speak. So for example, a company could decide that it's prudent not to provide investor updates, particularly if the company is not financing, not selling securities, not otherwise putting out favorable press releases, and not make any updates and not affirmatively provide any new information on its financial condition or results of operations. So if we go, I guess before I leave that point, of course, companies that are thinking about all of their communications and their engagement with investors, as Jen will talk about in a little bit, are going to have to consider the pattern that they've established over time. You're not going to want to be in a position of releasing good news if at the same time you are holding on to and holding back potentially bad news. And that's often referred to as the bad news doctrine. Now, if you're, again, financing, you have to think about that context, and you also have to think about how all of this may affect blackout windows that the company may have. So to the extent that a company is affirmatively choosing to put information out, that may allow the company, for example, to lift its trading window. The other thing to think about, of course, is Regulation FD. So Regulation FD was adopted to address the issue of selective disclosures of material information. And the goal, of course, is to make sure that there's a level playing field and that all investors have access to material disclosures at or about the same time. So it's easy to think about how Reg FD fits in the scheme of periodic and current reports, Qs, Ks, 8Ks, and so on. What becomes a little more difficult is to think about Reg FD obligations outside of those quarterly reports. And in that context, we have to think about information that a company may be providing to a group of potential investors, and whether that information is non-public and hasn't otherwise been disseminated, and of course whether that information is material, and the parties with whom that information is being shared. So it's always possible, even in the context of Reg FD, for example, to share material and non-public information with advisors, with certain partners that owe the company a duty of confidentiality, or in the context of an offering to wall-cross investors, and then those investors, of course, will owe the company a duty of confidentiality, and the company would not have been deemed to have violated Regulation FD. So Reg FD is something, both materiality and Reg FD are two sort of core issues that companies are going to have to be thinking about on an almost daily basis during these particularly volatile markets. And as the company heads into its earnings announcements, and then as Eddie will talk about in a little bit, as companies think about financing in the immediate aftermath of having put out their earnings, when there might be a lag between the earnings release and the 10Q. And with that, I'm going to hand things over to Jen to talk about earnings announcements and investor calls.
Thanks, Anna. So regarding earnings announcements, there's been plenty of information released recently about how the current earnings season will be historic due to the COVID-19 pandemic and its potential impact on businesses. For example, on April 8th, SEC Chair Clayton and Division Director Hinman released a public statement specifically addressing earnings releases and analyst and investor calls. And Mike will discuss this a little later on in our presentation. But the general compliance considerations and best practices continue to apply to companies that release earnings. So I will discuss some of these compliance considerations for earnings releases and their content, and the best practices for investor communications. As Anna mentioned, there is no duty, generally no duty, for companies to disclose information, except when required by a specific SEC rule or regulation, or in certain other circumstances. And earnings releases and earnings calls are not required by the federal securities laws. But when companies do choose to disclose information, as many do for earnings, the disclosure must be complete and it must be accurate. So substantive disclosure in earnings releases and related calls must comply with the general anti-fraud provisions of Section 10B and Rule 10b-5. In other words, earnings releases and information provided may not contain material misstatements or omissions. And as noted toward the end of this slide, an earnings release triggers a current report on Form 8K as the disclosure regarding a company's completed quarterly or annual period. Next, earnings releases and calls by a company will consist of MNPI, material non-public information. And with that information, since its release is intentional, as Anna mentioned, the company needs to ensure that the release complies with Reg FD, which means simultaneous public disclosure. Another key consideration is ensuring that forward-looking statements made in earnings releases and related calls are protected under the applicable safe harbor. And Laura will discuss that safe harbor in some detail later in our presentation. But companies will need to review and update or supplement their safe harbor information. And Laura also in a few minutes will provide information on key compliance considerations for non-GAAP measures and KPIs. And finally, when an offering is planned for close in time to earnings, a company should also ensure that it can rely on the Rule 168 safe harbor regarding their statements. So with an understanding of the base compliance considerations, a company, of course, needs to consider what to include in their earnings releases without including too much detail, but including enough to be useful to their analysts and their investors. So companies often use non-GAAP measures, KPIs, and in this regard, it will be useful to keep track of what others in their industry or peer group are doing. And the use of these measures will be different this earnings season based on COVID-19, as we will discuss more later. But of course, all of this needs to be considered in connection with what will also be covered on the earnings call. And the earnings call can, and almost always does, cover more information than the actual earnings release, so it goes into more detail. As a compliance matter, this is allowed. Item 202 of Form 8K provides an exception for the disclosure of MMPI made orally, so by telephone or webcast, which would include an earnings call. But among other things, the earnings call must be announced by a widely disseminated press release, and I'll talk about the best practices for that in just a minute. So the company will also need to consider its pattern of communications, any other communications being made to investors or analysts by company representatives after the earnings call to ensure that those do remain consistent with information disclosed in the release and on the call. But those communications can also be problematic from a Reg FD and Section 10b perspective. So I'll also provide some best practices on that in a bit. So consider all of this in connection with the SEC's views on earnings releases, as the SEC certainly focuses on them. They look at consistency of disclosure across company communications, including with a particular focus on social media. And as Laura will discuss, the SEC has been increasingly focused and has provided substantial guidance on the use of non-GAAP measures and KPIs. So in connection with how a company should provide earnings information, both the release and information on the earnings call, the SEC has expressly approved certain procedures. So I'll take these in sequential order of how a company typically complies with the SEC's approved procedures and with both Reg FD and Form 8K. So they'll typically issue a widely disseminated press release, and that usually is 1 to 2 weeks prior to the earnings call with instructions. They'll issue the earnings release no more than 48 hours prior to the earnings call and file the release on Form 8K. And finally, a company will post information that it intends to disclose during the earnings call, including information regarding non-GAAP measures, to its website. And just a bit of timely advice, if you need to reschedule or postpone an earnings call that's already been scheduled due to either COVID-19 or other issues, the company will need to issue a new press release and provide as much notice as possible of the change. And maybe it won't be the full 2 weeks, but it should be long enough to be adequate for investors. So I want to spend just a minute on guidance, since this has been a particular focus since the start of the pandemic, with companies trying to determine if they need to update or withdraw guidance or what they will do in their upcoming earnings releases. And this is all in connection, of course, with the April 8 statement, which urges companies to focus on disclosure and future operations and goals. So guidance will be particularly difficult during this time. There's plenty of challenges for companies, yet investors and analysts may still be looking for it. And we expect that many companies may not even provide guidance, or it will be very limited, and hundreds have even withdrawn annual guidance up to this point. But if you're not providing guidance, a way to provide investors with some insight could be in line with the statement by Chairman Clayton and Director Hinman, provide forward-looking information on certain things, maybe your response and plans to COVID-19, some challenges. So companies that are, of course, faced with this dilemma of providing useful guidance and other forward-looking information while trying to protect from liability. So to help here, you'll certainly want to update your forward-looking statement cautionary language, but it's also important to think about disclosing assumptions and explanations regarding your guidance and statements as well. And once guidance is provided, it's critical for companies to be very cautious about subsequent communications in order to remain in compliance with Reg FD. So when dealing with analysts, remember that MMPI cannot be provided without simultaneous public disclosure if it's an intentional disclosure, but the same also goes for any affirmation or withdrawal of any prior information provided. And it's important to understand here that the SEC interprets language by a company very broadly, so simply repeating previously disclosed guidance will generally be a Reg FD violation unless there's simultaneous disclosure. And also, any indication of trends or future results can also be a problem, including through body language or tone of voice. So this explains why many public companies have a strict no-comment policy regarding confirming guidance when it comes to one-on-one conversations and other methods of communication. So I'll pause here to repeat the CLE code. It's on this slide. It's 04MB23EC. And please include this code on your affirmation form. To repeat the housekeeping, both the affirmation form and the evaluation form are found on your resources widget on the screen. So moving on, and carrying through with a theme of earnings-related information that's consistently messaged. Of course, earnings calls aren't the only time companies speak with the investment community. You need to be mindful of compliance anytime a company representative speaks. So your policies and procedures apply to earnings releases and calls, but of course they apply equally to subsequent analyst calls or investor conferences and literally any other setting where a company employee can be seen to speak as an agent of the company. As I mentioned earlier, social media activity is a particular focus for the SEC. So now is a good time to remind all employees of policies regarding communications, including social media. So finally, some suggested practices on how to interact with the investment community and remain compliant with the securities laws. As already mentioned, coordinate all of your company communications and inquiry responses. Determine who will speak on behalf of the company. Ensure that person is trained and carefully prepares for the communication. And one way to immensely help with this is to script calls and presentations and to try not to deviate from that script. Consider also preparing perhaps a Q&A for your investor relations team if you haven't already for COVID-19 inquiries. But remember that this should be consistent with and no broader than your existing public disclosure. And for analyst and investor meetings, consider also having at least 2 company representatives attend. And this is important to help track what information is communicated, but also to potentially have a second person that could act as a Reg FD traffic cop of sorts to intervene if the message goes in the wrong direction. And if a call or presentation does deviate from your script, have a team ready for follow-up. Perhaps it's the chief compliance officer and or some legal counsel to help determine if public disclosure needs to be made under Reg FD. If you don't have a strict no comment policy with respect to follow-ups on information that you've provided, be very careful about your response so the company isn't seen as reaffirming or withdrawing any information. And this is particularly useful to think about when reviewing research reports by analysts. If you must comment, only correct errors of fact in the report. And lastly, understand that compliance with communications policies and with Reg FD are certainly likely to be more difficult right now. Due to COVID-19, company insiders may have more material non-public information than usual and may have it for longer than usual before it's publicly disclosed. So I'd like to pass it on to Laura now, as I mentioned, to discuss non-GAAP financial measures. Laura?
Thank you, Jen. As Jen has already mentioned, if a company is going to be using non-GAAP financial measures in its earnings release or its 10Q, you need to consider how you're going to be complying with the applicable SEC regulations. Now, the SEC has 2 sources of non-GAAP financial measure regulation. The first is Item 10 of Regulation SK, and that applies to SEC filings. Reg G, on the other hand, applies to all public disclosures. And a key concept in both of those areas is that you need to be reconciling your non-GAAP financial measure to the most comparable GAAP measure. Regulation G specifically prohibits use of misleading non-GAAP financial measures. So don't use a non-GAAP measure if taken together with accompanying information contains an untrue statement of a material fact or omits to state a material fact necessary in order to make the presentation not misleading. As this slide indicates, there are non-GAAP measures that the staff has already determined in its compliance and disclosure interpretation are inherently misleading. Be aware of those and stay away from them. Another point that's of paramount importance for non-GAAP financial measures is that you need to provide greater or equal prominence to comparable GAAP measure. So the GAAP measure has to be at least as prominent as the non-GAAP financial measure. And the staff has provided many examples of what failure to give equal prominence looks like in its CD&Is. This is an area where the staff is likely to give you comments, and those comments may not just be for a filing. It may be comments on an earnings release, that are furnished on an 8K. And as noted on this slide, the prominence considerations can apply to headlines and captions in earnings release. So that's something you need to consider carefully when you're reviewing it in earnings release. You should also be aware that there's specialized guidance in this area. So remember that the non-GAAP compliance and disclosure interpretations can be a very useful resource, and you should turn to them. In addition to the prominence point I already mentioned, I want to highlight a few other areas that are frequent sources of staff comments. For example, be sure to provide the reasons that you're using the non-GAAP measure, why it's useful. Be careful about the titles you're using for your non-GAAP measures. And be sure when you're doing your reconciliation that you're doing it to the most directly comparable GAAP measure. And also consider whether characterizations of adjustments are appropriate. So what's new this earnings season? As Mike's going to be talking about, the Division of Corporation Finance recently issued disclosure guidance, topic number 9, and in it there's a few key takeaways on non-GAAP financial measures in the context of COVID-19 disclosures. So one, companies presenting non-GAAP financial measures adjusted for or explaining the impact of COVID-19 should highlight why does management find this measure useful, and how does it help investors assess how COVID-19 is impacting the company and its financial position, and et cetera. Also, in the earnings context, companies for COVID-19 disclosure are permitted to reconcile provisional amounts based on reasonable estimates or a range of reasonably estimable GAAP results. But you have to have appropriate explanation in that disclosure. So for instance, if a company is going to be disclosing EBITDA on an earnings call or in an earnings release, it has a choice. It could reconcile the measure to GAAP earnings or to a reasonable estimate of its GAAP earnings that includes a provisional amount, or its reasonable estimate of a range of GAAP earnings. But when you have a document that requires GAAP financials, which means your 10K or your 10Q, you have to reconcile to GAAP results, and you can't use the provisional amount or a range of estimated results. But it does give you flexibility for the earnings release. Also, companies should be using non-GAAP financial measures for the purpose of sharing how management and the board are analyzing the current and the potential impact of COVID-19. They shouldn't be used for the purpose of presenting a more favorable view of the company. So now moving on to key performance indicators, which Jen also alluded to. Back in January, the SEC issued guidance on key performance indicators used in the management discussion and analysis. And although that guidance was issued before the COVID-19 virus reached pandemic levels in the United States, it's relevant to the upcoming COVID disclosures. Many types of metrics can be KPIs. For example, same-store sales, active customers, numbers of account holders affected by data breaches, and employee turnover rate are just some of the ones that were specifically mentioned in the guidance. And the KPI guidance reminds companies that when they include metrics in the MD&A, they need to include further material as may be necessary so that the metric is not misleading. Based on the facts and circumstances, what the SEC is looking for when you use a key performance indicator would be disclosure that clearly defines the metric, tells you how it's calculated, lets you know what assumptions or estimates are used, that explains why the metric provides useful information to investors, and also discusses how management uses the metric in managing or monitoring the company's business. Now, if you're going to use KPIs in an earnings release or other presentation, you may also need to discuss that in the MD&A. I think people will be expecting that. And if a KPI is material to investment or voting decisions, which it may be, then it's important that your disclosure controls and procedures are specific enough to those KPIs to be effective to ensure consistency as well as accuracy. And you also need to consider whether the metric is understood or if it's being customized, that there's a process by which you document its calculation. So now I'll move on to forward-looking statements. And as has been mentioned already, it's particularly important in the COVID-19 disclosure where the pandemic's impact really began to hit strong at the end of the first quarter, really at the end, so it may not have even had a particular impact for some companies on the first quarter. But it's now a very uncertain environment, and it's particularly important that companies avail themselves of the statutory safe harbors for the information. There's one both under the Securities Act and under the Exchange Act. And to be sure you're doing this, be sure that you identify statements as forward-looking and indicate clearly that actual results may vary and give some of those reasons. Examine the context of what's being said to determine if information is forward-looking as opposed to a historical reference. So, for example, if you're describing growth, did it occur during the period that just ended, or are you talking about opportunities for future growth, which would be future? And there's a number of words that typically signal a forward-looking statement, such as believe, expect, anticipate, intends. There's many of them, and it's useful to add such words to your forward-looking statement so there's no doubt that people understand you're saying something about the future and trying to come under the safe harbor. And in that context, I mentioned that quotes from the CEO or anybody else in an earnings release often contain statements that can be construed as forward-looking. So it's a good idea to review the earnings release carefully with an idea to coming within the forward-looking safe harbor, including for quoted statements. And also think about meaningful cautionary language. Many companies include a litany of factors that could impact actual results. I suggest adding one for the effects of COVID-19 and expressly and placing it near your top of your list. You could elaborate as appropriate by mentioning its duration or unknown long-term economic impact, measures taken by the government to address the pandemic, and the manner in which the pandemic may exacerbate other risk factors and uncertainties. So be careful that you update cautionary language. Describing something that has already occurred is not going to be an adequate way to describe why actual results may vary from a forward-looking statement. And of course, don't offer a forward-looking statement if the company has actual knowledge that it would be misleading. So I'll close my remarks by pointing out this list on the slide of things to keep in mind from a forward-looking perspective. So be sure you're updating your forward-looking statements and risk factors. Don't say something that's already happened. Don't describe boilerplate information regarding trends, because that may not reflect your current situation. And do allow time for counsel to vet your disclosures. And one thing you may want to consider is providing management insights on the impact of COVID-19 without getting specific about the guidance or level where you're expecting to reach, or you may want to discuss forward-looking possibilities based on a continuum of assumptions explaining what those are. So with that, I'll turn the program over to Mike.
Thanks, Laura. I'm going to talk about two pieces of recent guidance from the SEC that issuers should keep in mind when preparing their earnings calls and investor updates, following the points that Anna, Jen, and Laura have been talking about. They've already touched on some of the information in this guidance, and I'll try to avoid duplicating their remarks and focus on specific COVID-19 matters that the SEC has raised that people should be thinking about. The first piece of guidance I want to talk about is CF Disclosure Guidance, topic number 9, issued by the Division of Corporation Finance in March. This topic provides guidance on disclosure and other security law obligations that companies should consider with respect to COVID-19. The guidance recognized that it may be difficult for companies to assess or predict with precision the broad effects of COVID-19, and that its actual impact will depend on many factors beyond a company's control and knowledge. At the same time, the guidance observed that, quote, the effects of COVID-19 has had on a company, what management expects its future impact will be, how management is responding to evolving events, and how it is planning for COVID-19 related uncertainties can be material to investment and voting decisions. The guidance addressed 3 broad topics, 2 of which are relevant to our discussion today. The 3 topics are assessing and disclosing the evolving impact of COVID-19, trading prior to dissemination of material non-public information, and reporting earnings and financial results. With regard to assessing and disclosing the evolving impact of COVID-19, the Division of Corporation Finance emphasized that under the SEC's principles-based disclosure framework, disclosure requirements can apply to a broad range of evolving business risks, even in the absence of a specific line item requirement that names the particular risk presented. This is sort of the SEC taking what Anna said earlier and not having a specific duty to update or an obligation to disclose. The SEC is trying to make sure that companies are thinking about all of the different ways that they might have an obligation to disclose, as particularly focusing on COVID-19. And in talking about this, the SEC identified a number of areas that are on this slide that could be necessary or appropriate for disclosure, including MD8 A, business, risk factors, legal proceedings, etc. So it really could flow throughout a disclosure document, and it's something that companies need to be thinking in mind. To illustrate the types of COVID-19 impact that could give rise to disclosure obligations, the guidance included a non-exhaustive list of questions for companies to consider with respect both to their present and future obligations. I'm not going to give all of them, but they're set forth on this slide and the next one. And as you can see from the list, the Division of Corporation Finance is suggesting companies really need to take a holistic look at all of the potential ways that COVID-19 can impact the business and then make their disclosure decisions after that analysis. The guidance encourages companies to provide disclosure that is tailored to their business, providing material information about the impact of COVID-19 through the eyes of management. In addition, the guidance encourages companies to proactively revise and update disclosures as facts and circumstances change. And in light of the way that everything is moving right now, that could be quite often and quite regular. With regard to reporting earnings and financial results, the Division of Corporation Finance encouraged companies to address the impact of COVID-19 in their upcoming earnings calls and be prepared to answer COVID-19 related questions. For at least this reporting period, investors and analysts are going to be very interested in how COVID-19 is having an impact. And as Jen mentioned, it's important not to selectively disclose MNPI on COVID-19 related matters to any investor individually, but to disclose it in the earnings release or quarterly report or on the earnings call, some Reg FD compliant method. The guidance recognized that the ongoing and evolving COVID-19 situation may present a number of novel or complex accounting issues that, depending on the particular facts and circumstances, may take time to resolve. Therefore, the guidance encouraged companies to address financial reporting matters earlier than usual, consulting with experts as needed. These views were reinforced by a subsequent statement released by the SEC's chief accountant. I think there's probably three other important takeaways from the guidance, focusing on the non-GAAP measures that we were talking about earlier. First, if a company presents a non-GAAP financial measure or performance metric to adjust for or explain the impact of COVID-19, it would be appropriate to highlight why management finds the measure or metric useful and how it helps investors assess the impact of COVID-19 on the company's financial position and results of operations. Second, if a GAAP financial measure is not available at the time of the earnings release because COVID-19 related adjustments require additional information and analysis to complete, the Division of Corporation Finance wouldn't object to companies reconciling a non-GAAP financial measure to preliminary GAAP results that either include provisional amounts based on a reasonable estimate or a range of reasonably estimable GAAP results. And third, when a company presents non-GAAP financial measures that are reconciled to provisional amounts, the company must only include non-GAAP financial measures that it uses to report financial results to the board. Companies should use non-GAAP financial measures and performance metrics for the purpose of sharing with investors how management and the board are analyzing the current and potential impact of COVID-19 on the company's financial condition and operating results. And here's an important point, not for the purpose of presenting a more favorable view of the company. The second piece of guidance I want to talk about was also mentioned earlier. It's the joint statement that was issued on April 8th by SEC Chair Clayton and Division of Corporation Finance Director Hinman, titled, "The Importance of Disclosure for Investors, Markets, and Our Fight Against COVID-19. In the statement, they urged companies to provide as much information as is practicable regarding their current financial and operational status, as well as their future operational and financial planning. And they provided several observations and requests for companies to consider as they prepare their disclosures, focusing primarily on forward-looking statements. Going deeper into some of the things that Laura was just talking about. These observations and requests build upon previous guidance issued by the Division of Corporation Finance, including the guidance topic number 9 that I just talked about. There are several important takeaways from the joint statement, including, first, high-quality disclosure will not only benefit investors and companies, it will promote valuable communication and coordination across the company. Company disclosures should reflect the current state of COVID-19 affairs and outlook, and in particular should respond to investor interest in where the company stands today, operationally and financially, and how the company's COVID-19 response, including its efforts to protect the health and well-being of its workforce and customers, is progressing. I think an important new point coming out from in this joint statement is thinking about the disclosures not only from the company perspective, its investors and the markets, but also how it might be able to help the overall fight against COVID-19. And that requires people to think about it, all the disclosures, from a slightly different mindset. A second thing, important takeaway from the joint statement, is that providing detailed information regarding future operating conditions and resource needs is challenging but important. In light of the unknowns that still exist, The SEC recognizes that companies will have to make a variety of assumptions, including some that relate to factors that are beyond their control. Third, first quarter earnings reports and related investor and analyst calls will not be routine. Historical information may be substantially less relevant as shareholders want to know where companies stand today and how they have adjusted and expect to adjust in the future as they continue to deal with COVID-19. And following on one of Anna's points earlier with regard to materiality, is that when thinking about your materiality standard for disclosure for this quarter or for upcoming quarters, is that it may be different and may be lower than what you have thought about it in the past. So not only do you need to think about the impacts COVID-19 is having, you also need to think about, in light of the interest in the company and how it's being impacted by COVID-19, what's the appropriate standard to judge materiality. Fourth, good faith attempts to provide appropriately framed forward-looking information would not be second-guessed by the SEC. This is important in following on some of the things that I think Laura was mentioning earlier, which is they're really trying to encourage forward-looking information here. They think that's what people are really going to want to be wanting to be knowing about. Two more points. Fifth, they noted that investors and markets may be particularly interested in how the company's operations and financial condition may change under various COVID-19 related mitigation conditions, which may necessitate these detailed discussions of current liquidity positions and expected financing needs, whether the company is receiving or intends to apply for financial assistance under various COVID-19 related federal and state programs, including the CARES Act, and how such assistance has had or may have a material impact on the company. And lastly, companies that respond to the call for forward-looking disclosure should avail themselves of the forward-looking safe harbors in the U.S. securities laws. The SEC has said that they're not going to second-guess good faith judgments on forward-looking statements, but the SEC isn't the only party that's going to be looking at these, so it's important to comply, to try to comply with all of the protections that are available under the securities laws. Before I turn it over to Eddie, one other thing I want to mention. The SEC and its various divisions and info offices are coming out with a lot of COVID-19 driven or related guidance and relief, including for public companies in dealing with their disclosure obligations, SEC filings, shareholders, and markets in general. The SEC has a link on its homepage to its response to COVID-19. That link takes you to a page that identifies the actions the SEC has taken since the beginning of the pandemic, broken into 5 main categories. The one that's relevant for our discussion today is the category titled Guidance and Target Regulatory Assistance and Relief. If you haven't looked at that page yet, I encourage you to monitor it for their latest pronouncements with respect to their COVID-19 related guidance and relief. And with that, I will now turn it over to Eddie.
Thanks, Mike. Let me just add one more thing to what Mike was just talking about in terms of SEC relief. As people are coming out with their 10-Qs, their guidance, their earnings releases, and needing to be making SEC filings, one of the issues the SEC was trying to provide relief on is late filings. One thing I'd like to urge everybody on this webinar to understand is that an awful lot of companies will be filing earnings releases on Forms 8K and especially 10-Qs all around the same time, and financial printers are very backed up right now, and financial printers are all working from home as well, and time at the financial printer is really slow. So unlike other times when you may try to get things in at the last minute, please try to think a little bit ahead. So now I'm going to take you to the last portion of our webinar today, and we're going to talk a little bit about undertaking securities offerings post-earnings announcements. As Mike said, one of the issues that the SEC has talked about is companies' liquidity positions and access to capital during the time of the COVID pandemic. And so just want to talk a little bit about that. While this was obviously pre-end of the quarter, March was the largest volume in the investment-grade bond market in the history of the investment-grade bond market. Nearly $260 million was issued in March as people were trying to fund before the end of the quarter and before they went into blackouts. April, I know some bankers were hoping for a little bit of relief during earnings blackouts so that they could actually get some sleep, but the beginning of April has actually, and into the end of April now, has turned out to be just as busy. So a lot of companies are out there trying to fund, in some cases, just trying to borrow money so that they've got cash on hand because they don't know when they're going to be able to access the market. The beginning of March, the market was a little bit more choppy, and there were days when deals weren't getting done. The markets have seemed to have calmed down a bit, and so their access to liquidity seems to be a little bit better. But in any event, people are certainly looking at offering securities. So typically companies go into blackout towards the end of the quarter. Some companies go into blackout a little bit before the end of the quarter. Some don't go into blackout until into the new quarter. It really all depends on the company and when management has visibility as to what the earnings from the prior quarter are going to be. Certainly we saw at the beginning of April there were some companies that were pushing their blackouts back, the beginning of the blackout back just a little bit to be able to get financing in. To be clear, just because a quarter is over and you haven't announced earnings doesn't mean you can't access the market, but it certainly puts an awful lot of strain on your ability to provide full and fair disclosure. So obviously year-end companies, March 31 was the end of their first quarter, and a lot of companies now are looking to finance but don't want to wait until their 10Q is filed. Of course, we certainly have clients, and it's not uncommon for people to issue their earnings and file their 10Q on the same day, but that is typically more companies holding off the earnings rather than accelerating the 10Q. So a lot of companies want to be able to access the market very quickly once they've got their earnings out. So first question to deal with is, as I think everybody knows, when you issue your earnings, you have to file a Form 8K with the SEC under Item 202. To be clear, I use the word file, but really the SEC requires you to furnish that 8K, meaning that the 8K is not incorporated by reference into your 34 Act filings. There's good reason for that. Oftentimes the earnings release is going to contain guidance, and people don't necessarily want guidance in a document subject to 33 Act liability. There are some companies, though, that do file their earnings release, and the earnings release would then be incorporated by reference. If you're going to undertake an offering, be very careful about whether or not the 8K is filed or furnished. Do it very thoughtfully. As I mentioned, some companies don't want to incorporate their earnings release because guidance is in there, or there are certain other disclosures that they may not want to take 33 Act liability on. Just as important, and maybe not, maybe more important, underwriters often don't want earnings releases with guidance or forward-looking information to be incorporated by reference, because they then take on liability for statements of the company. And certainly anything that's in an earnings release, if it's incorporated by reference, the underwriters will want comfort on. So they'll want comfort on all of the numbers in it. Obviously it's difficult to get accountant comfort on forward-looking statements, but as opposed to just line items that we'll talk about in a minute, they would want comfort on the entire earnings release. So first question, do you file or furnish the earnings release? If you're not going to file the earnings release and it's not incorporated by reference, then it may be appropriate in that circumstance to include some highlights from the earnings release in the offering document. Now, some of that may depend on how quickly you're going to finance after the earnings release. So, for example, if you were to issue earnings on Monday afternoon after the close of business and you wanted to launch a bond offering Tuesday morning, that might be a very close in time situation where the underwriters would say, while technically the information is out there, we want to make sure that investors have easy and quick access to it, so therefore we'd like to have a recent development section in the prospectus with some highlights. Typically the highlights are relatively few. There might be top line revenue, bottom line net income, a couple of balance sheet items, but it would vary depending on the industry that the company is in and the situation that the company is in. So you should check with the underwriters about what they feel they need for marketing purposes. In addition, if you are going to put disclosure in, if you're going to put some numbers in your document that are in the earnings release but before the 10Q is filed, it may be appropriate to have some disclosure about how there could be changes in the numbers between the earnings release and the 10Q. Here we have an example of disclosure that was put out by somebody just a couple of weeks ago. In fact, I think it was last week. And the disclosure they put around the earnings said the financial results are preliminary and may change as a result of the completion of our financial closing procedures. Importantly, it hasn't been reviewed by PricewaterhouseCoopers in that case. In some cases, your outside auditor will make you put in disclosure like that, but in any event, you want to put something in to make it clear. These are in the earnings release. They're not in the 10K. All of our final closing procedures may not have happened, and they certainly will not have been reviewed. As long as we're talking about disclosure, I think we heard a little bit already about COVID-19 things. You certainly want to have disclosure in your document about both what the company has done, sort of a recent developments about how COVID-19 has impacted the company. For example, we saw a number of transactions that came out by companies that had stores that were entirely closed. So, for example, TJ Maxx and Ross stores, two very large retailers, disclosed that all of their stores had been closed. They had furloughed many of their employees. So you want to have an update in terms of what's going on with the business. And very importantly, you also want to have an update of your risk factors. In general, in the investment grade bond market, the risk factors in a prospectus supplement are limited to the risk factors relating to just the offering. However, virtually every single one of the deals that have come out in the last 6 weeks have had very specific COVID-19 risk factors. Again, you don't necessarily know exactly what the impact is going to be, but there are certainly those risk factors. As companies now start to file their 10Qs, some of those risk factors may just be incorporated by reference, but both issuers and counsel and underwriters and counsel should be looking at what those risk factors say. Another important aspect is diligence. So if we're now going to go out with an offering in between earnings release and the 10Q, the underwriters are going to want to do a little bit more due diligence on the company's quarterly earnings. So for example, the kinds of questions they might ask are, what quarterly procedures have yet to be completed? How significant are they? So if you've reported $1 a share in earnings, how much of that could change? What kinds of things still are yet to be done? What kinds of procedures do independent auditors have yet to complete? For quarterly information, outside auditors tend to do very little in terms of assurance as to the numbers, but again, what are they going to do? What factors could change that? Another question is historically, going back 3, 4, 5 years, how often have the company's 10Q filed numbers differed from their earnings release numbers where there's been a difference in time? Other kinds of things that you want to think about in terms of diligence, even though they may not necessarily relate to the earnings release, are guidance changes, confirmation of ratings. So a number of different things that the underwriters and counsel will want to do in terms of due diligence. Comfort. In connection with all securities offerings, in connection with all public offerings, certainly in 144 offerings, the underwriters or the initial purchasers will want to get a comfort letter where they have the company's outside auditors tick and tie specific numbers. So if the company says our revenue was $1 billion, the auditors would say, yes, we've looked at that, we've compared it to the company's financial statements or books and records, and we agree with that. That's part of the due diligence process to make sure that those numbers are right. In connection with an offering like this, certainly the underwriters would like to get a tick and tie of the quarterly numbers in the earnings release. Unfortunately, many accounting firms would say that either they're unable to do that because the company's financial statements aren't done yet, so they can't tie them back to the company's financial statements. Some accounting firms, though by no means many of them, may tie them back to the company's books and records, since the company does have books and records that will show the revenue, or to a schedule. Some accounting firms take the view that once the company announces its earnings until the 10Q is filed, the auditors or the independent accountants don't want to be associated with those numbers, and so therefore will not give any tick and tie comfort on those numbers. One way to get around that, because again, the underwriters will want some level of assurance that those numbers are accurate and complete, is to get a CFO certificate. Another aspect of a comfort letter is what's called negative assurance, that there haven't been changes in certain line items, so for example, revenue or net income or debt since a certain date. Again, in this case, it would probably be from December 31st. And while the numbers have been published, so the accountant should be able to say, well, we know that for the first quarter, the company's revenue went up or it went down. Accountants typically, once an earnings release has come out, will not give any negative assurance going all the way back to December 31st, even if there are monthly numbers for January and February. So again, that's an issue that you'll need to work through earlier in the process if you're an issuer, and certainly underwriters will want to talk to counsel about. One way to bridge that gap is, again, with a CFO certificate. One word about pre-releasing earnings. So we've talked about earnings releases. Well, there are companies that are in significant need of liquidity right away and may not have bank lines available to them or may not have commercial paper available to them and need to do a financing before their earnings are even out. Obviously, we've been talking now for close to an hour about the earnings. There are some companies that can pre-release earnings and then go out with that. So pre-release earnings are often done in either an estimate or ranges or preliminary numbers, and there are a number of companies that have done this. It is relatively uncommon, but where a company needs to finance, they can pre-release numbers, estimates, ranges, etc. The due diligence aspects of that obviously are a little bit more stringent because you're really going to want to try to get a comfort level to the extent that you can with how good those numbers are or how good those estimates are. And the disclosure around those will be even more significant, and I've provided an example of what kinds of disclosures people have said. So with that, I think this brings us to just about an hour. We thank everybody for participating and listening in, and if you have any questions, feel free to email them in to us. I think you all have our contact information, and a copy of the slides will be made available to everybody that listened in, and a recording of this will also be available on our website and will be available for people to get afterwards. So with that, thank you very much, and on behalf of Mayor Brown, please everybody stay safe and healthy.